Folks, we're back. This is Steve Stanson and Stephanie Phillips with another episode of Veterans in Politics. Today we have Bill Henderson, Clark County District Court Judge, Department R, Family Division. But before we get to Judge Henderson, Ms. Phillips.
Thanks for joining us, everybody. And thank you to our sponsors. We have Semper Fi Heating and Cooling. It's getting hot out there, so give them a call to get your system checked. Their website is callsemperfi.com. Callsemperfi.com. We also have Mayor Michelle Romero. She is running for re-election. Her website is votemichelleromero.com. Votemichelleromero.com. Hop on there and check out her platform. We also have a Board of Regents candidate for District 3. It's Angelo Carvalho. And his website is carvalhofornevada.com. And that's the number 4, carvalhofornevada.com. Check out his platform. And we are having a CD4 candidate advertise with us as well. And he's coming on the show tonight. That'll be our second show. If you would like to advertise with us, if you have a business, a nonprofit, or you're a candidate, get in touch with us on that. We've got a few spots left, and we'd love to talk with you about that. Also, we have a merch store. It's vipimerch.com, vipimerch.com. We have lots of fun stuff on that website for you to check out. And also, don't forget to grab your copy of Steve's book, How to Navigate Nevada's Family Court System. If you are a litigant and you don't have an attorney or you can't afford one, this is a self-help book. You can get it on Amazon. It is $14.99, and it will help you through that system. And he'll even autograph it for you. And also, we're planning our ball, our Valentine's ball. It's February 7th of 2026, and I know that's a little ways away. But we are going to have extra early bird tickets on sale July 1st. That is coming up very quickly. So be on the lookout for those. There's only so many of those early ones to go around. So you're going to want to jump on those quick. Also, for my rant, as everybody knows, President Trump struck Iran's nuclear facilities. And it was stunning to me that all the people out there, the media, and actually people on both sides of the aisle. I heard Trump was starting World War III. He didn't get congressional approval to start a war, declare war, and all this. And I'm thinking to myself, other presidents have made strikes like that. Obama sent plenty of bombs over to Syria. Reagan bombed Libya. I mean, this was an airstrike, and this took out their nuclear capability. Now, Clinton, Obama, Trump, they all said Iran cannot have nuclear capabilities. It was okay when Hillary Clinton said that. It was okay when Obama said that. But, oh gosh, when Trump says that, the media goes bananas. So instead of criticizing Trump, the media should have been complimenting and saying how grateful they were to our brave men and the female pilot in those B-2 bombers, the refuelers, the jets, and that mission that they went on. Nobody else in the world could have accomplished that. It was absolutely incredible. So bravo to them. Thank you for your service. Thank you for being brave. But what happens? What's his name? The guy from Texas that filed impeachment. Al Green, what's his name? I think that's his name. The Democrat from Texas files articles of impeachment against Trump. Here we go again with impeachment because he fired off at Iran. So what's stunning to me is, and of course that was voted down, but people need to get on the right side of America. If you are supporting and you're a sympathizer for the Iranian regime, go to the country and live there. You won't last long. You will want to come back to the United States. So we need to support our country, the United States. We need to be united and defend our mighty red, white, and blue. So get on the right side of that and stop being sympathizers for an evil regime that only funds terrorist groups. They were just chanting last week and the week before, death to America, death to Israel, burning our U.S. flag. How can anybody defend that or stand behind that? I think that it's absolutely disgusting. And then after we struck them 3 days later, we have a peace deal and a ceasefire. So no, he did not declare war. Yes, he has the power to do it. Read Article 2 in the Constitution, and it didn't start World War III. Bravo, President Trump, and to our United States military.
That's interesting. And I wish I could comment directly on political things, but what Stephanie discusses, it highlights something that's disturbing in our society. Take an issue like that, international matters of military action, things like the pandemic and the vaccination, global warming. So many people look at it through the lens of politics. For example, on global warming, you believed in it generally. If you were a Democrat, if you were a Republican, you tended not to. The vaccinations, the Democrats tend to support it, the Republicans didn't. And then everyone gets on the soapbox and say, oh, it's about science. And so many people don't really, and that's refreshing because you've done a deep dive on these issues. 80 or 90% of people, sometimes I fear, don't really study the science, the economics, the military aspects of things, but just go with what the talking heads of their party tell them. And statistics bear this out. I mean, how many people who offered an opinion on global warming or the vaccinations actually did a deep dive on any of the multitudes of research, which admittedly would be boring and hyper-technical and difficult to comprehend. So, I mean, it's really interesting what you're saying, because I think perspectives are largely colored by politics, even when they should be colored by, is this a military issue? Is this an economic issue? Is this a scientific issue? And Americans have a tendency to look through everything these days through a polarized political lens, it seems.
And I believe that is the fake news media. A lot of that is their fault because they stir up people. They have these little bullet points, talking points, narratives that they put out there. People get upset. And that's all they listen to, but they don't do the research behind that. But this issue, this is protecting the United States of America, all of us. This isn't, and this isn't against the Iranian people. This is against the Iranian regime, and they cannot have nuclear capabilities. And I'm very glad that he took that out and took away that capability, because I think our world is safer all the way around.
And I just want to say, all you people that defend the Iranian regime, go live in Iran. Because I remember when the Shah left Iran.
I remember that too.
Yeah, when the Shah left.
They've become westernized for a couple of decades, for lack of a better term.
I mean, even Bing Crosby back in the 70s were in Iran singing. You think Bing Crosby or any artist could do that today? No way. So there you have it. Well, Judge Henderson, thank you so much for coming.
Thank you very much, Steve.
Could you give us a bio, please? Don't leave anything out, because I got it all right here.
I've been on the bench now for 16 or 18. Yeah, and as I said, I want to pass over a lot of those more embarrassing moments. But I've been on the bench 16, 18 years, practiced about 20 years before then. But I don't think anyone is here to hear me read a boring resume about what I might have done 20, 30 years ago. They're looking to jump right into family court. And for a moment, may I take this?
Yes.
This book, Navigate. Everybody needs to buy this, even whether you have a lawyer or not. Those without a lawyer, you need to buy this. I mean, if you go to the Self-Help Center at Family Court, sure, they can help you with some forms, and I'm a supporter of the agency. But this really does a deep dive in basically each step of the process and what you need to do. And when people go back to the family court or self-help center or whatever drafting agency helped them draft their documents, and they said, well, then I went to file it, and they said, this part was missing or this requirement wasn't in place, and I'm getting frustrated. This is the fourth time I'm back here. This book basically telegraphs those problems and indicates, here's some of the pitfalls that you might be facing. And if you rectify them beforehand, your documents are going to slide through. So I think this is an invaluable resource. I think everyone should purchase it.
Thank you.
And what's on sale for now at this point? Navigate, how to navigate.
That's right, on Amazon.
Amazon, $14.99.
I'm not a paid pitch man. I'm not permitted in my judicial position to advocate for any for-profit type of situation, but it's a nonprofit enterprise, and it's from a nonprofit agency, and I think it helps people immensely and will help the people who can't afford lawyers save an enormous amount of money, and even the ones who can afford lawyers. And I know of 3 instances already of people who owned this book or consulted this book, and it not only saved them hundreds, but thousands of dollars and untold aggravation, and you need to pick up Navigate.
Thank you.
How do they get hold of it? How do they order?
They go to Amazon.com
Okay.
and just put my name in there or Navigate, whichever one they want to do, and it will just pop right on up. But Judge Henderson, how long have you been on the bench now?
16, 18 years now? Yeah, quite a while.
I remember when I used to drive by you and you used to take the hammer and you was knocking in those rebars.
Unfortunately, if I have to
Knocking
do
in
that
those
again, I
rebars.
was a younger man then, but I'll have to go through that again now. So we'll see how I hold up through that enterprise. But yeah, and things have changed. Like when I got on the bench is when it was transitioning to technology and the Odyssey system where everything's on the computer. Back then we used big buckets of files and everything was physical, the reports from the specialists. Yeah. And that was when that all happened. And that's a double-edged sword, I guess. But I guess there has been that technological shift. And I guess it's best more good than bad in the long run, though.
I want to talk to you a little bit, if you don't mind, about some of the people that come into your courtroom. And there's a couple names that come to my head, and you don't have to go into specifics.
Please don't mention them specifically.
Oh, that's just tying our hands, Judge.
I can certainly express an opinion on a lot of policy matters or problems.
Okay, we have one attorney that he says he's not a public figure. But yeah, he does CLE classes for judges and attorneys, and he writes quadros, and he tries to, I put it in my opinion, steal disabled veterans' benefits to pay his attorney's fees and costs. There was a rumor going around because I did a deep dive into this guy, and that he did that years ago. He was in Carson City, and he went into a Sears store, and he was working as a clerk for Supreme Court Justice, and he went into the ladies' restroom and he masturbated on 2 14-year-old girls, and then they hid that, and then I'm hearing as I do more and more investigation into this family attorney, I hear that he did this circle jerk thing, had circle jerk parties. And I'm like, this is a family attorney. How do you feel about these attorneys coming into your courtroom with this type of resume?
Well, obviously, if something like that was absolutely verified, that would be extremely problematic. Mm-hmm. But I would have to wait until I'm not copping out. But I'm kind of required. I'm not permitted to comment directly. But I think I could comment directly if it got to a point where someone was actually prosecuted for an offense. But it sounds problematic. Now, is that just one party's version of the events, or is that some sort of actual...
Several people mentioned that.
Okay, but is it actually from a law enforcement agency that those facts were verified, that people were prosecuted? Sometimes things get really grossly distorted. I'm not saying that happened here. Right. But I'm saying that,
How do you feel about?
How do I feel about those actions? Obviously, they're deplorable, but I don't know who committed them or whether they committed them in the way it's described. But obviously, that would be deplorable, and that is not commensurate with people representing our families. We have to protect children, right, and we have to, for lack of a better word, wholesome, conscientious, right, moral people protecting our children.
And the same attorney has this one attorney that actually lost his bar license because he was soliciting a 14-year-old girl, and he got convicted of that. And now he hired that one attorney. I think he got his license back by now, but he hired that one attorney when he didn't have his license into his law firm to do legal matters, still looking at, minors, photos and all that. You're right. It is deplorable. It is deplorable. But I want to get...
And I'm not exactly sure what's being referred to, although there's a couple hints in there that I think I know a couple of the people that might be referring to. But unfortunately, that sort of also parallels with a few other matters I've heard about other individuals. But it's really an interesting, almost controversial issue in that when you have the state bar administer certain punishment, and then sometimes the Supreme Court will say of our state, that's not severe enough. This person should lose a license forever, or more than the 1 or 3 years that the state bar said, and it should be 5 years, that type of thing. So, I mean, the intersection between morality and law is always a dicey, challenging issue. But far more so, there's a much brighter light shown on it in the family court realm. I think in the criminal realm, we understand there's serious moral underpinnings, crimes being committed. And it's sort of all out there in the open, but that's not, because that's part of the process. This person's charged with this, et cetera. In family law, you're dealing with something much more complex on these issues.
And recently, get this, that same attorney did jury tampering.
Did you ask Judge Gordon these questions?
No.
Or did he have an easy go of it?
No, I didn't.
Well, how come I have to be asked these and not him?
Because it's different. It would be boring.
Not that I'm wishing it
It'll
on
be
Judge
boring.
Gordon.
You've been on the bench
He
longer.
comes to mind just because he was on last week. So.
It was boring if I asked the same questions of each judge.
But did you ask him questions quite as challenging and personal and centered?
Oh, yes.
Oh, you did?
Oh, yes.
I have to watch the whole broadcast.
Yeah, you gotta
I saw
watch.
most of it,
You gotta
and
watch.
I got
We had
so.
Jacob Reynolds on too. You gotta watch.
Oh, good guy.
He's a good guy.
Mm-hmm.
So, and recently the same attorney did some jury tampering, and then the judge ordered a mistrial in the matter. Matter of fact, the case was against this attorney. He did jury tampering. Judge ordered a mistrial, and then about a year and a half later, that same judge that ordered a mistrial gives him a pro bono award. And I'm like, what the heck is going on? I'm bringing this up to you because I don't understand what's going on. Why can't, I'm not the only one saying this?
What that might be. I'm thinking of actually two different instances, and I'm not sure which one this one applies to. But just to play devil's advocate for a moment, most of these reportings to agencies are confidential until an actual prosecution or case is open. So how do we definitively know? I'm not saying the judge did or didn't. I'm not taking up for one way or the other. How do we know definitively that she didn't report? Maybe it was reported, and they're, as you know,
But that's public, right?
Well, Stephanie, that's kind of interesting because I think, and I could be wrong on this, you guys are a lot more involved in that disciplinary area than I am, and you brought matters before the State Bar, the Judicial Commission. Mm-hmm. Unless it's changed, and it may have, I could very well be wrong. I think the investigation aspect is confidential and private, but once they approve it and open an actual prosecution against a judge or with the State Bar, the lawyer, then it becomes public. Whether the aspect of their investigation should be public or not, I don't know, but a lot of people are accused of all sorts of things. And if we made public everything that some good judges or lawyers are accused of, some bizarre matters which have no basis in reality, no one in another profession would want that. Whether you're an engineer or teacher and someone says, let's say, oh, he's a satanic worshiper. And back to the thing you mentioned where, oh, he's underage kids and he's doing these horrible things. An investigation like that in most professions should be private because it could be bizarre, it's repulsive and it's untrue, and it could destroy that man or woman's career. But if the agency charged with this sees that there's enough arguable merit to it that they're going to prosecute him, then I think basically that should be made public generally, no matter what type of disciplinary body we're dealing with, what type of professional, whether therapy, and it does come up in the therapeutic realm as well. So I basically do believe investigation should be private. And then if it's approved for a prosecution, for lack of a better word, then I believe the public and media has a complete right to know and should know.
Do you think that this is a good old boy town with some of these attorneys that go in the courtroom? Do you think that some people get away with stuff and some people don't get away with stuff?
I don't think we can deny that any large city, and Chicago, people used to say, was more of a quid pro quo. There you go. See what age is doing to me? Town where you did this for me.
Right.
And that's what I was told when we start practicing. Large cities like that, quid pro quo, where it's more, you did something for me, I'm going to do something for you, a favor. While Las Vegas is more of a juice town, not necessarily you owe me a favor, but it's who you know. And I think in the sense that was starting way back when I started, like in the 80s, without naming the judge, you would go in and see a prominent lawyer who was on the other side of a case, and he'd be sitting in there with the judge who maybe plays golf with, or the family socialized together. And a few times I even heard from the hallway, they were discussing the case. And we wouldn't have dreamed, even though it was technically against the rules, and I suppose people wouldn't have dreamed of reporting that unless they could really prove it definitively. Right. If it was, I kind of suspected, I think I overheard something, I know I saw the guy in there. These days, I don't think most judges would want to risk, if there's a significant case coming up, that one of the lawyers would be in their office discussing that. So I tend to think, and maybe I'm being naive here, that as our legal profession's grown exponentially here, I think there's less of that by some degree of measure than there was back in the 80s, where it was really quite disturbing. But, opinions can differ on that. But I'm seeing, and they're controlling access a lot better. You can't just drop by a judge. Everything's electronic, and they don't let people through and all that. Back then, you could just walk into a judge's chambers.
I want to talk about something that bothers me probably the most. One of the things about family court, and about judges in general. When you guys put out an order for someone to do something and they don't abide by that order, such as pay child support, submit their financials, and things like that. These people, some of them get away with not paying child support for years and years and years. And some judges don't do anything about it. So when you have a situation where somebody repeatedly will not follow your orders, regardless of what they are, what do you do?
Stephanie, that's an excellent point. And there's no doubt that there's a lot of validity to that. And I think a couple things is the contempts have been made very difficult. And our appellate courts, the Nevada Supreme Court and our Court of Appeals, as well as the Nevada Judicial Discipline Commission, seem to really frown on contempts in family court. But I think in extreme matters like that, where it's more of a clear-cut, defiant non-payment of child support by someone who can easily pay, I think you do still tend to see, that's where you if there is any aggressiveness left in the enforcement of contempt, you still tend to see it there, and the DA Child Support Division doesn't hesitate to incarcerate the people there. But if you've got the private attorneys in the family court matters, and you're trying to incarcerate someone on a denial of visitation, and it kind of seems murky, and these people have their excuses, and unless you can really definitively determine it's pretty much 100% someone's fault, and it makes it very difficult. And that's another thing, is usually people get really frustrated when they're being denied, and they behave in such a way that you would say, well, it's 30% this person's fault and 70% this person's fault. And then a contempt, and I kind of do tend to agree in the family court realm to a large extent with the philosophy, with this approach that I sense is on our appellate courts and also within the Judicial Discipline Commission, that if you're going to pursue a contempt, and there's some pretty specific steps that you now have to satisfy. And I think if it's something in the realm of anything beyond a very clear contempt of a child support order, it's very difficult. You pretty much have to look at someone who's an innocent victim versus someone who's getting away with deplorable actions. And the problem is, these matters involve the things that are most emotional and important to people, their children. So they don't tend to calmly say, okay, I was deprived of visitation. Some do. I'm going to make a note of this, call my lawyer, and we'll proceed with contempt. Sometimes people take actions which could and do validly result in counter contempts, where this is some pretty outrageous behavior. And I'm not suggesting that that's a synopsis, a valid or anywhere near a complete synopsis of why I think this point you raised, which is excellent and very valid, why this tends to manifest itself that way. But at least those are my thoughts on the subject. For example, if you got a guy, I'm not going to support these freaking kids. She doesn't want to be with anymore. Why would I? And the guy owes $125,000 and he makes $250,000 a year, and he's just, I'm not going to pay that $1,000 or whatever it is. I mean, I think that's a much clearer road to contempt, and that's where you see most of the contempts. But if you have people complaining about this additional visitation was blocked, or he didn't inform me about this medical appointment, I had to find it out from someone else. And then the forms from the self-help center, and in many cases it should be to enforce or clarify or to establish an order. Everything seems to start out as to show cause for contempt. And it puts us in a difficult situation because you check the box. And we say, we're not going to hold someone in contempt because they were 2 days late getting you the insurance forms or things like that. Or there was some argument about, do you get this additional vacation day? Those are things that maybe lend themselves more for clarification. But when you see people playing games, even with those type issues long enough, you tend to get more clarity on what's occurring, and then maybe contempt is more appropriate. But that you hit the nail on the head. That's an ongoing issue. And we do have to be circumspect. And if we're hesitant, it's because there's a lot of rules and pressure that control us to be so.
How about there's this one particular case where the father he's an attorney, by the way, hasn't paid child support for 6 years, owes over $500,000, friends with the judge, sealed case, so that you can't.
I hope it's not mine. It doesn't sound familiar.
No, it's not you. Familiar. No. And, complaints filed with every agency possible. I mean, this poor woman has been through the ringer. Not one dime of child support. He's an attorney. He can afford it. Friends with the judge. The judge lets him get away with murder, basically, that quote unquote murder. Those kind of cases. And where's the accountability on that? It's no wonder why people get frustrated with family court, because people like that, and especially sealing the case for no reason. There's no children. The child is of age now, and an adult, but he keeps it sealed. In this particular case, and things like that should not ever happen.
Well, I agree, and that sounds outrageous, and it very well could be. But I've learned the hard way is people are told these like red meat, certain basic facts of a case. I'm not saying that applies here. I'm sure you've done your homework, but I'm just saying there's a lot of cases where I'm confronted with the a parade of horrors. Like, look at these half dozen facts. Almost invariably, when I go back and said, before I render an opinion, I'm going to watch every video on that case and read every scrap of paper file. And sometimes I'll emerge from it and I'll say the person was right. It is outrageous, but not nearly as outrageous as they said, because there's a lot of nuance here. There's a lot of other things going on. Now, that's not making an excuse in the event that this actually is, if it really is that simple and straightforward, that it's uncontroverted that these two are close friends, and that the attorney clearly has the capacity to pay and hasn't even been making partial payments. But that would be one of the first things I would look at. Is there some degree, at least, of partial payments being made? And if it's just 0, 0, 0 across the board, he's making hundreds of thousands a year, and it was that simple, and he didn't reference any health issues or anything else that suppressed his income for a while. If there aren't any qualifying factors or additional key factors beyond what you mentioned, I mean, if it really is that straightforward, obviously that is highly problematic if it's that straightforward. I don't have any idea which one that is currently, but I have seen cases over the years where it was asserted that a judge and a lawyer were friends, and I may have had some knowledge that they did have a friendly relationship, but it seemed to have been exaggerated by people as to, was it just cordial professionally, or was it also of a more personal nature? We have to look at that too, because people, when they come to you and complain to that as a lawyer, and they say, oh, these judges, this judge and lawyer are great friends. And there was a seed or foundation of truth in it, but then I found out they were cordial in planning seminars and all, but it's not like they shared a San Diego condo together and stuff. Yeah. So, yeah, but those are the matters we need to really watch out for. Because one horror story like that, when the media reports it, it kind of destroys all the progress of when you're trying to build integrity or rebuild integrity within a system. And if you've got thousands of cases that are sort of going okay and to the best of the ability of the judges and the lawyers, and there's just one or two of these horror stories, that individual horror stories that are red meat for the media, no one wants to hear about the 99.8% of cases where no one's complaining and they're unproblematic. And I understand that. And that's why when we see those cases, we have to weed them out because, and my colleagues will say, well, what about no one wants to talk about all the thousands of cases we do where no one complains. They complain about the one that catches media attention or the Judicial Discipline Commission attention. I say, well, you may be right about that, and you are, but it doesn't make any difference because that's the reality of it in every single profession. There's going to be certain individual instances that really resonate with the public as unfair, outrageous, and that's what's going to attract people's attention, and that's what's going to attract media attention. Now, as far as like, if you see, well, to the extent, but are there systemic problems on the thousands of other cases to an extent that people don't hear about? And I know you believe that there is, and that leads to like a lot of the protests and all. Then you have a systemic problem with systems in general. If it's not just the individual horror stories.
We haven't done a protest in a while.
Yeah, right.
Maybe we should.
Right. Well, not now because it's going to be 110 degrees.
That's when we did them.
Yeah, right. Because that's tended to get, sometimes that attracted the media's attention because they say, this has to be valid. These people at least really care because they're out here in these conditions. Ergo, it's more newsworthy. Therefore, we're going to go out there.
So Judge Henderson, what do you think about SB 432, Senate Bill 432, that makes it a felon if you talk about your family court case?
If it's sealed.
Well, I think even though I have opinions on sealing versus not sealing versus the circumstances, it certainly seem to be.
What requires a sealing?
Well, here's what I would say about that.
Let's start there.
I would find that a really overreaction, regardless of whether I was a strong sealing proponent or a non-sealing proponent. It just seems disproportionate. Now, if someone wants to say, is it a gross misdemeanor? That probably is too. But I think instead of criminalizing it, maybe it should, if someone honestly believes that's improper, and to speak to the public about their family case, and I don't think it is, but if the powers that be think it's improper, I think what would be, even though I wouldn't agree with that, I could at least understand dealing with it proportionally. There could be a sanction within your family court case, but to involve outside prosecutorial agencies, if that's a feature of it that's being considered and would be passed, I think things are sort of doomed from the inception when there's a disproportionate penalty overreaction. It would be unusual to convince enough Democrats and enough Republicans to get together and support that. Because if you're going to criminalize as a felony discussing your family court case, I think the issue there is a grotesque overreaction and not really the issue itself. Because regardless of how I feel about the issue itself, whichever side I was on, that just seems to be way out there. And I heard about sanctions. I have to admit, I wasn't aware, although I've heard some rumblings about criminalizing. I didn't hear the felony part. So maybe I obviously need to go reread the Senate bill because
what would require?
I don't get it.
SB 432.
Yeah, 432.
And it was signed.
I didn't know 432. It mandated that it's a felony.
It passed. It's a Class D felony. It was passed. And shame on you, Governor Lombardo, for signing that.
Yeah, I've got to read because there's something wrong. And I did hear something about criminalization or some criminal penalties, but I should have read or reread it in its final draft because I didn't hear there's a felony to discuss your case. Because, it's to the sealing or privacy issue, as you know, I'm a believer in open court. These are the public's courtrooms. They pay. People have a right to know. I think there may be some, and I understand the other view. These are, for the most part, highly personal matters.
Right.
That's painful. It doesn't involve the public.
They should mediate. If
right.
they don't want the public courtroom, they should mediate.
And I understand juvenile matters.
Because that's private.
And juvenile matters need to continue, of course, to be private. But, I'm kind of torn on this because the matters that do have public interest and media interest or indicate to the public and the media a good example of how our courts are working or not working so well, and it's your tax dollar, I think we have the right to know. And on the other hand, there is the privacy concern, but maybe also people would be a little more careful. Maybe there shouldn't be a right to privacy if you're going to falsely accuse someone of horrific things.
Exactly.
And it actually has a freezing effect on that, according to studies in states which don't have much in the way of private cases and file sealing. People tend to be a little more circumspect in what they're going to say. There's far less accusations of people abusing children, physically, sexual, otherwise, particularly in smaller areas where they know there's geographic areas, lower population, where they know there's no privacy protections. Things tend to get reported. People more tend to confine themselves to the truth and not gross distortion or hyperbole, at least according to some people who've studied the issue.
What would require sealing? What is the law that governs sealing?
Well, that's why I'm not really.
That's a two-part question,
right?
And if the court observers walk into a courtroom and the attorneys look around and like, oh my God, I don't want them here. Oh, Your Honor, could we close this case? Yeah. And isn't there a NRS that governs that?
Yeah, that I don't like.
Yeah, you can't just seal on the spot.
Exactly.
Right.
If you guys didn't care enough to seal beforehand and there weren't compelling privacy concerns or protecting minors beforehand, and you just want to willy-nilly clear the courtroom, which you could have 10 years ago without much repercussion. If these are members of the public and they're going to behave themselves, or support systems of family and they're going to behave themselves, they're going to remain here. Sometimes that's an issue because even when I tell people, if you're here to support your son and daughter, that's great. The first time you blurt out, roll your eyes, distract the proceedings, then that's different. Then I'm going to change my viewpoint pretty quickly on whether you should be here or not. This isn't the Jerry Springer show, with all due respect to the late Jerry Springer, but that's the point. And that tends to turn it into a carnival and a free-for-all. And I'm not going to tolerate that. But and you've seen, I have no right to. Now, if that was something so critical that it was sealed beforehand, then that's different. But if people say, oh, we don't want people here, if you cared enough beforehand, so you should have taken action. If you didn't, you're just not going to omit the public on a whim, or support system of the well, these people going through the toughest times in their life, for them to have their current spouse, a sibling, their mom, their dad, that can sometimes help immensely. Sometimes it goes in the opposite direction. So I guess I'm sort of conflicted on it because I think there are sensitive cases and it should be a case-by-case analysis. For example. Right. Well, it's a little difficult to say because cases that had this element would be probably sealed anyway, because there's probably, if you're dealing with children being abused, there's probably an attached CPS or juvenile cases in many instances, so it would be sealed anyway. But I think in cases where, let's say, it does involve material about a minor, either something a parent did to them or something that the minor themselves may have done or being accused of doing, and it's disturbing to know that everyone in the universe could find out with this 13-year-old who's going through an extremely troubled period and might have made some real mistakes and their mind is still forming and all that, particularly in this hyper-electronic age, I would think, look, I would say, okay, let's protect this 13-year-old girl, this 15-year-old boy. That type of analysis, case by case, but to just say we should autocratically and authoritatively, because we're the lawyers or prominent lawyers or we're prominent judges, just say the public has zero right to know about matters which are intensely private. Well, it's a little tricky because, again, number one, sometimes people don't lie and exaggerate so much when they know the public accountability and it can be viewed. Number two, the public has a right to know how their tax dollars are being used in this court and what services we're receiving. Three, freedom of the press and the media to inform us of critical underpinnings that affect our lives. And four, practical, the most practical, the other three are more broad policy, but for a practical matter, people say, I'm going to go into that court next week myself, or my daughter's going into that court. I'm panicking. I would like the ability to maybe just sit in, see what works. Watch the judge. What upsets her or him? What's the best way to approach them? What should I emphasize? What should I not emphasize? I think that can be very valuable. So I guess the more I start peeling away this issue, the more I feel conflicted, but I generally fall on the side of these are public courtrooms. They're funded by tax dollars, and there's something of a lien there. But on the other hand, there's going to be individual cases where I'm probably going to be pretty fierce about not wanting the public to know, not so much protecting deplorable behavior of parents, but what may be occurring with a 13 or 14-year-old either being allegedly victimized by a parent or their own terrible choices. I don't want the kids at school saying, oh, I didn't know you were doing coke, to the 13-year-old. Oh, I didn't know you were sleeping with boys or doing this or that. There's that type of situation. So when it comes to minors, we need to protect it. Right. And I think mainly there's a focus, So
you're going to be surprised when you go through this bill. Because it's very...
Somebody may be a guest.
In my opinion, it is very broad. It gives the judges wide latitude to just seal it. And it can restrict, like you were saying, family members, advocates, to help the litigant when they're already in a stressful situation. Silences the public. You can't... And this goes into effect October 1st. So a lot of what we do in helping litigants, advocating for them, court observing, these different things that we're involved in.
Very valuable.
And that just erases all accountability when everything is silenced and shut down and sealed. We can't do some of the things then that we do now. And that's why I'm appalled that the governor signed it, because to me, it's a direct violation of the First Amendment. And there's already a lawsuit. Didn't they file a lawsuit already on that to challenge?
They're waiting until they come after somebody like me.
That'll happen.
Sometimes, these situations where sometimes a sealing or protecting is, and you don't want people to get hold of inflammatory information and use it to publicly shame or horrify or embarrass a family. Then on the other hand, though, most of the time that's not what's occurring. Most of the time people do just sincerely. Most people who've come into court are either court observers or connected to the parties. I don't see too many media personnel occasionally, or ones who I'm here as a media figure or from an activist group, although that does occur as we're talking about Steve and you all. But most of the time, it's family members there as support, friends or family members, or people who have an upcoming case and kind of want to reduce their pressure level, get more comfortable with it, and see, what is this judge like? What sets them off? How should I present my case? And there will be people, on the other hand, who just want to take this material not to learn from or not to educate themselves or the public, but there are people who will use it to embarrass and disgrace families. And maybe the adults can be expected to be pretty thick-skinned because they're willing to put their whole lives in court. But again, there's a lot of material about minor children in these divorce custody cases that are not attached to a juvenile case that don't have the benefit of the protection. So I just think the issue should really be parsed out intricately in all those aspects like you all are doing. But instead, I think it's just too polarized, the sealing side versus the unsealing side. And no one wants to recognize that this is an issue dominated by nuance and qualifying matters. And most of these cases are somewhere in the middle where you would struggle with and say, gee, I think that case should be sealed. So I'm thinking it should really be a case-by-case basis. And what you mentioned about, Stephanie, about giving wide latitude to the judge, maybe that's a double-edged sword and there's a positive part of it. Wide latitude to the judge to seal, but does it likely give wise latitude to the judge to maintain it open? And to look at it that way. Now, that's a good way to look at it, providing that judges do exercise that discretion in that analysis and not jump to more of a sealing aspect, because that's what it seems most attorneys who have weighed in on this seem to want the cases sealed or private. But
some judges
a lot of them haven't offered a view, but the few that do.
Some judges have bad behavior in court. I mean, we've seen them yell at litigants, swear at them, call them names. I mean, we've seen these videos. And that is disturbing. So to me, that just will hide that fact if because they don't want to be called out. They don't want people to see that side of them. And
it's all relative too, because people wouldn't have a problem every day of my life, every day, every calendar pretty much saying of this 40-minute hearing, excerpting 30 seconds that would make me look bad. And maybe many instances that I do. I shouldn't have lost my cool. All I would ask someone like that, before you broadcast something like that, draw broad conclusions from it, watch the whole 40-minute video and say, oh man, that guy was just jumping all over you, wouldn't let the judge get a word in edgewise, was insulting the other side, et cetera, et cetera. So it's good to have as much material as possible before rendering.
So you've been on the bench, 17 years?
Yes.
And during that 17 years, what's your percentage of pro se litigants in your courtroom?
It's an excellent question. I think it's changed. It's got to be. You might know better than I.
And
you might have been
move
tracking
up
that.
since
It's probably more than 60, isn't it?
And did you did the percentage move up?
Yeah,
since
I think so. I could be wrong about this. I think when I took the bench way back in the Stone Ages, I think it was 50-50, but still leaning a little more to representation, like 52 to 48, 54 to 46. Then when I hit the 5-year mark, it turned 60-40 pro se. And now some have told me it's more 70-ish. I don't know if that's an operation of the economy and some of the real dips we've had over the last decade or two, although I suspect that's a major reason. Or number two, the internet and organizations like yours and others empowering people and providing them the tools to handle a lot of matters themselves. You guys would probably have a better perspective on the causes of that. It's probably not just economic, but it's probably also these materials are more accessible. We can go to the internet, go to organizations like this, not just have forms handed to us, but receive guidance. Well, if it was 20 years ago, you may have to go to an office supply store, go to the legal area and purchase some documents. And maybe there's an instruction sheet, which is next to worthless because those documents used to be like for generic and not necessarily tailored to particular states. So I think maybe that's one of the reasons why we're seeing, but we sure are seeing a lot more of it and moving more and more toward it. Also, another factor I thought could be that lawyer fees are exponentially increasing which of course they will, everything will, but at a greater rate even than the cost of living or incomes when those happen to be increasing.
I got another question.
Problem. Yeah.
With regard to lawyers' fees, do you think lawyers should make less if they do a Zoom than show up in person? And do you give more credibility to lawyers if they show up in person versus a Zoom?
I have a very strong opinion on that. And I say, look, this is available. I can't mandate you to be here, I don't think, unless it's a trial or evidentiary hearing where we're taking evidence. But First of all, it's very difficult to hear sometimes. It's very difficult, and some hookups on some days are particularly bad. And even when the hookups are all right, or when they're bad, it's compounded by problems. People don't want to know when they're muted. They get distracted. They're not speaking or talking right into the camera. There's other stuff going on at their home or their office. So what you're receiving just audio-wise is painfully inferior, even under the best of circumstances. But I do think there are psychological underpinnings you've identified. If it's let's say when it's acceptable, and I don't mind, a status check, we still need another month, we're discussing settlement. All right, I get it. I would have done the same thing if that was available when I was in practice, particularly if I have another hearing or two that morning. I'm running between courtrooms, even buildings. That would be a perfect situation. We're just asking for a continuance or something, or all we want, Judge, is something minor, set a deadline for signing the real estate papers or something. I get it. But if it's a case of first impression where you're in on temporary custody support and everyone's throwing everything, put the kitchen sink at you. And yes, someone appears with their lawyer in court, sometimes waits in the hallway now. We try and avoid that, but that can be a long wait. Wouldn't you tend to think that person cares more, takes it more seriously? And sometimes you find out that that person hasn't been paid any more than the video person. Sometimes they've been paid less. So I think I can't help it if I'm just like everyone else in life. Of course, we're judges, but we're still the human element. If people are here saying, I care, I want to make sure that nothing's misconstrued, that I'm heard, that you see us, you know how much I care, that we waited an hour here. We drove through the spaghetti bowl. We were behind an accident. We got here and we waited because you were behind on calendar, and here we are. Well, we hook up with someone and all you so yeah, I mean, but that doesn't mean I'm an advocate for requiring people to be there. But I'm saying if you're going to use your judgment, but then use it soundly. And it's not sound judgment if you got a brand new hairball case where people are fighting for custody, allegations of abuse, you name it, and financial accusations, and you collected a $10,000, $15,000, $20,000 retainer from that person. I think you should be appearing in court. It doesn't mean I'm glad the video is available. I'm glad it's there in many cases. I appreciate it because lower range matters move more quickly. We just want a new date. We need more time to settle. Okay, here's a new date. But on those real hairball motions where people are arguing about child abuse and financial dishonesty and violence and all these things, you should be there with your client, in my opinion.
You speak about all that, and a lot of attorneys and litigants just say stuff. Do you go by the rule of evidence and ask them to prove what they're telling the court?
Of course, and sometimes that's here's the real problem. That's what I think, and that's the double-edged sword, and that's what judges struggle with. Like, are you going by the evidence? And then on the other hand, when you say yes, and that's why this person didn't get what they demanded because they didn't have the evidence. And then they tell everyone in the internet, this judge still gave him part custody, even though he's a child molester. And I had all the evidence. And the evidence, in many cases, consisted of what that person was saying. So to them, we didn't follow the evidence. But where did the evidence trail actually lead us in that hypothetical? Multiple reports to CPS therapists, the police, who all concluded there's nothing to see here. This is just artificially created to deprive a man or woman of their custody rights to their child. So usually when people complain a judge didn't follow now sometimes the judge doesn't follow what seems to be the weight of the evidence. But the irony of this all is if you follow the evidence, you actually get criticized more often than not, because they'll say, that monster didn't follow the evidence. He didn't care that my child, most of the time, in other words, you'll be accused for not following the evidence when that's exactly what you did. You followed it to a T. You haven't proven that he's done these things. You don't even have any evidence that would suggest he or she or her new boyfriend did this. So you follow the evidence there or lack thereof, and then they accuse you. I had all this great evidence. What? Your word against everyone else's? And you look at that. A parent has every motivation in the world to tell us this is occurring, but you look for the neutral specialist and what they're telling you. And again, there's problems with that. They vary in quality or conscientiousness. There are police, CPS workers, therapists, evaluators, psychologists who they vary remarkably in quality, conscientiousness, how deep they went into it. But with that said, when everyone's pretty much doing their job adequately or better, you go by what those third-party agencies that exist for the purpose of protecting children, not what someone says when that seems to be all it is, well, this is what my child told me. And even in those cases, you say, okay, if that's all you have, what you're telling me, and no one else has any evidence, but you say, just speak to my child and you'll know. Then you speak to the child, or you assign someone, it all immediately falls apart like a house of cards. The child, it crumbles. They're not saying that. The mom or dad rehearsed them, but then it falls apart right away because the child's telling the truth. And it's hard to rehearse children as to fantasy matters that don't exist, that they didn't concretely observe. It's very difficult the younger the child is. Then some of those parents go back to the drawing board and then, well, try some other way to fabricate it. So there's a lot of false allegations, and even something worse, taking a seed of truth or a foundation of truth and thinking that justifies distorting it out of all proportion.
Well, talking about CPS and some of these cases where they go in and remove children, and you've got conflicting medical reports. You've got experts saying that the initial report's wrong. You have no criminal charges against the parents. The parents have a stellar, background, reputation, no history of abuse at all. And these cases sometimes get drug out, and sometimes these kids are babies, and you're removing an infant from a mom who's breastfeeding. And because the court, for whatever reason, they take forever, months and months and months. Meanwhile, this baby is away from her mother, and she's not able to care for their infant or their children and the kids involved. Why does it take so long when you can see, when there's no criminal charges, there's conflicting medical reports, there's all these inconsistencies, there's no direct evidence or proof that the parents harmed these children? Why does it take months for a judge to put his foot down, her foot down, and say, you know what, listen, there's no proof here. I'm going to restore these children to the parents? Why does it take 6 months, 8 months, a year? And CPS and the DA drag these cases out, and these kids are harmed, and so are the parents.
That's an excellent question, and it's a big problem.
Huge.
And I don't have any solutions or meaningful suggestions except to point out things are really complex. When CPS goes in there, they have to make an immediate call based on the circumstances. So they have to say, is it more likely than not that something's going on here? So they do remove children. Then what happens?
Don't you think they jump the gun sometimes?
Well,
They're
there
a little
cases,
trigger
there
happy.
are cases, and we don't sometimes know it till afterwards. And we see those other matters, like where what you're saying. I'll say, look, I'm not a fool who thinks we're going to solve this problem in 10 days, but can we solve this in 3 months? In an ideal world, we should be restoring children to someone right away if there's nothing there. But I say, and I say that a lot. I said, I don't want to be back here in 9 or 10 months or 12 months. But if I have to be back here in 2 or 3 months, if that's what we really need to get the investigation completed for this person we assigned to complete their work, that's what we're going to have to do. And I think one way that I've helped shorten that for my court is to say, no, we're not doing it. Well, we've agreed to appoint this custody specialist. We're going to split the fees and get him or her on. No, we're not, unless we get them on the phone now and they tell us, if they say, oh, I'm backed up, it could be not. No, if they're backed up and it's 9 or 10 months, no. If there's 6 months, no. If they say, yeah, I'll try and get it done in 3 months, and we know it's someone who we always get a letter from asking for an extra 90 days, no. That's why I get them on the phone. I said, I want a quick turnaround. We're not going to have time for all the forensic testing. Here's what we want. We want some interviews. We want an investigation limited to this, this, and that. Can you get that to us? And we need to be looking. I said, in an ideal world, if children are falsely removed, we would want to correct that within hours or days. Exactly. That can't happen. But can it be corrected in weeks as opposed to 6, 8, 9, 10 months? Yes, because when I see people dragging their feet like that, I see the longer everyone drags their feet, the longer I'm beginning to suspect there's no meat to this and it was a wrongful withholding. And what seems to be more common than utterly wrongful withholdings is sometimes an overreaction to things. Now, there's a lot of cases, usually, and to be fair to CPS, there's so many cases that don't attract attention of anyone because we say, oh, yeah, I'm glad they took action. Because you either need the police or whatever Metro's unit is for crimes against women or children. You need, and that's the problem. When things are really, really an emergency, I tell people, if you have a few weeks to solve a problem, make it a judicial issue. Come to us if you have a few weeks. But if all you have is a few days because things are so bad, then you make it a CPS matter. But if things are so horrible right at the moment, something's happening to a child, it's a police matter in my mind. Yeah. Something that's happening right now is a police matter. Something that's deplorable, but it's not the end of the world. If we get to it in a few days or a couple of weeks, it's a CPS matter. But something that's going to languish a month or two, then if you're able to wait a month or two and it's not that horrible, then you can look at the courts as the first line of attack. But usually they're third. It's usually police, CPS, and courts. And to my mind,
it seems like a lot of these are one size fits all because you have the case plan and you have therapy and you have all these parenting classes and all this same stuff, which I'm sure the people that are making money on the other end, it's like, to me, it's a racket. You send these people that are innocent. They have not been proven guilty. Oh, go to this class, go to that class, get your certificate and come back in 6 months and see us. Why is it one size fits all when you can look at a case and you can look and say, you know what, there's conflict here. Why put these parents through this? Why do this when there is no evidence against some of these people, but you got to go through the system. You have to go through all this. Who's making money on the other end?
And there have been CPS cases where there was substantiation, at least temporarily, where I said, now that we've dug a little deeper and we're in court, there's nothing here. We don't have to wait 6 or 8 months and go through all those therapists. And it's interesting you point out, Stephanie, about these hired outside individuals. Mm-hmm. Most people can't afford them and they're relegated to the people who are paying the lawyers tens of thousands. They pay that to these outsiders. And someone said to me, wait a minute, I came from Michigan or Wisconsin, wherever he did. He said, there the court appoints these outsourced evaluators or people for the custody studies. He said, but I said, I know, but we don't have it here. I don't know if it's purely a funding issue or what it is. So he's saying, in other words, to protect your children and get one of these studies, you have to be wealthy. And I said, you're raising some excellent, disturbing questions I really can't answer. But yeah, these are real pricey and most people can't afford to go that route.
Judge, I know we could talk to you for a good 2 more hours, but we have another show.
Okay. Sorry.
But I just wanted to say this, that it's refreshing to hear you talk about things that some judges are just scared
and
to talk about.
Probably going to come after me about it.
Well, you know what? Let them come because
tell them to call us, Judge.
Yeah, because people need to know this, and I'm glad you had some gonads to actually do it.
Thank you very
That's
much.
what we need behind the bench.
Yeah,
people that are not scared to be judges.
I thought I sort of felt guilty that I sort of side-skirted a few.
Oh no.
Key matters.
Don't feel guilty.
Particularly the scenarios you brought up, because I didn't know specifically what instances.
I didn't mention names.
Yeah.
Well, we all know who we're talking about.
but Judge Henderson, Mark is going to zoom in on you. You could say whatever you want, come visit my courtroom or vote for me. And you running for re-election, right?
Yeah, I am. And that's exactly, you just said it all. And I don't want to take any more time, except
You work
I hope
Fridays?
the voters out here got something from this, and that you watch when all the judges and all the other political candidates come on. And you'll hear conflicting viewpoints. You'll hear judges and judicial candidates who feel differently than I, maybe dramatically differently. And the more information you have, then the better you're able to establish your informed opinions that are helpful to you.
Do you work Fridays?
Yeah.
Do you pack?
Well, maybe I shouldn't mention it. Maybe I should.
You don't have to answer it. You don't have to answer it.
I might be vulnerable.
You don't have to answer it. But Ms. Phillips likes to ask that
That's
question.
my favorite question, especially for the female judges.
Well, that's kind of interesting because in the rurals, that's almost a necessity. I had judges in the rurals who say we don't actually have marshals or bailiffs. Sometimes the deputy will have a deputy sheriff, but usually we don't. They'll be there to help out. We usually don't have those resources. So in those instances, although there's a number of judges here at PAC, almost all of those rural judges do for that reason. Yeah. And others.
Well, Judge Henderson, we really appreciate you coming on.
My pleasure.
And maybe we'll have you come on back sometime next year.
Absolutely.
Huh? Yeah.
I'd be delighted.
Well, thank you for coming on the program. Thank you, Ms. Phillips. Don't
No, don't go anywhere.
Jump the gun.
Folks, that's Bill Henderson.
That's right.
Clark County District Court Judge, Family Division, Department R. We hope that this program was informative and that you're able to relate to what Judge Henderson is saying. And then when you go to the voting booth, you're more educated on these judges. This is Steve Sanson, Stephanie Phillips with Veterans in Politics. Until next time.